SJC-12451, Cynthia Williams, personal representative, and another, v. Steward Healthcare Systems, LLC, and another.
Mr. Tennyson, good morning.
Good morning. May it please the court. I'm Chester Tennyson. I represent the plaintiff appellants in this appeal from the allowance of a motion for summary judgment in the Superior Court. The facts are not largely in dispute in this case. There was a court order to hold a homicidal patient. The only factual dispute that will exist is whether he remained a danger at the time of discharge, and there's conflicting testimony on that. The defense has offered proof that he was appropriate for discharge, and the plaintiff has offered proof in the form of an affidavit from an expert that he was not appropriate for discharge.
But is that the issue, or is the issue as to whether or not the hospital breached its duty of care?
Yes, I agree.
I mean, so it may be that somebody could find that that indeed there was a likelihood, but I would think you would have to go beyond that and say that essentially that there was a breach of the duty of care in so finding, because obviously these kind of predictions are difficult to make.
I agree, Your Honor. There are really only two issues in the case. Was there a duty of care that was breached? And the other issue is, is there immunity that is granted by Chapter 123, Section 36B? Now, this action was actually not brought against a licensed mental health professional. It was only brought against the institution.
But and that's what makes this seem so strange, your argument. No one could release him but a licensed medical professional, could they? I mean,
well, it would take a licensed mental health professional, but it doesn't mean that there wouldn't be that it wouldn't be overseen by someone at the hospital. The hospital is actually a corporation.
Well, but I mean, I'm confused by that. If a licensed medical professional or a supervisor of the licensed medical professional who's a licensed medical professional is going to make this judgment, it's
right.
not like, you know, someone else is going to decide this person can be released.
Right.
So that person's protected, but the hospital isn't? I mean, it just seems...
That's not really that anomalous, if we think about it.
Bill, give me an example where we've given immunity to the decision maker, but we're going to impose liability on someone who is not a licensed professional. It just doesn't make any sense to me.
As an example, the Massachusetts Tort Claims Act, employees of public employers are immune from suit. You can't bring an action against the employee of a public employer. However, that doesn't mean that the public employer is not responsible. The public employer remains responsible under the Tort Claims Act, even though you can't bring an action against the public employee.
For the conduct of the employee who's immune?
Yes, absolutely. For instance, if there's a car crash and the person works for the Commonwealth, you can't sue the operator of the car, but you can sue the Commonwealth. The employee is immune, but the Commonwealth is not. Chapter 123, Section 36B, affords immunity to licensed mental health professionals only. Chapter 123, Section 1 defines what a licensed mental health professional is. Any person who holds himself out to the general public as one providing mental health services and who is required pursuant to such practice to obtain a license from the Commonwealth. The same statute, Section 1, defines what a licensed mental health facility is, and it is a public or private facility for the care and treatment of mentally ill persons, except Bridgewater State Hospital. Now, importantly, Section 36B of Chapter 123 affords immunity only to the licensed mental health professional. It does not grant any immunity to the mental health facility. And I know that the defense is urging that 12336B be extended to cover facilities, but I would submit that really would require an act of the legislature to do so.
Now, you're assuming something that I don't know that we have decided. Have we ever decided in a case of this type that the 36B would apply?
Well, no. We purposely have not brought suit against any of the individuals.
You've made that decision.
Right.
But, and my question to you is there any case law that says when a judge finds somebody dangerous enough under Section 8 to hold, and the superintendent of that facility makes the decision that the person is no longer a substantial risk, or there's no longer a likelihood of serious harm, whether or not this statute would protect that decision and provide total immunity for that decision?
There is no case to that effect. The one that comes closest, I think, is the Shea versus Caritas case.
But in Shea, he was there voluntarily.
That is correct. This is an involuntary commitment. This is a commitment under a court order. So there is no case law that specifically says that 36B would apply to a situation where there is a court order.
Let's say that what happened here is what you say should have happened. So the hospital doesn't release N.
Right.
So what you have is you have a doctor
Right.
applying the art and science of medicine within presumably the standard of care, making a decision that based on the medical judgment that the person needs to be released because the order says, or not just the length of time, but until there is no longer a likelihood of serious harm by reason of mental illness.
Right.
And so the psychiatrist, let's say, makes that decision.
Right.
And then the corporate hospital says, no, we're not letting you do that. Isn't the hospital now in violation of the court order and confining that person against the law?
I think the hospital better have some justification for taking an action like that. I think
For unilaterally not following an order of the court, they better. You want there to be a cause of action. It seems to me that the first question is, would it be a violation of a court order for the duty that you're requesting to be imposed?
No, what I'm saying is this, Your Honor, that the final decision on whether or not this court order was complied with shouldn't rest with the one doctor. I think this court has review of that, but I think more importantly, that should have been reviewed at the corporate level at the Steward Carney Hospital before he was released.
I don't understand. You want the court administrators to review the decision of the mental health professional?
What I'm saying is this.
Did I miss that?
What I'm saying is this, Your Honor, is I don't think that the one doctor that makes a decision to release a person who has been ordered to be held because he is a homicidal risk, I don't think that's the final word on the subject. If we follow that to the extreme, no matter how wrong the decision is, it would forever bar any type of liability regarding violation of a court order. And I submit that is not and should not be the law. In this particular case, we actually have expert opinion that this is not the type of a decision. This is not a decision that a competent psychiatrist would make, and that this person remained a danger at the time that he was released. He was let out the door after assaulting other patients, assaulting the doctor, punching one doctor in the nose, refusing to take medications without a show of force, refusing to sign discharge instructions. When the family begged that he be kept, they were told, you better get a restraining order. So I think
how many, following that, how many levels of supervision does there need to be once there's a determination made that somebody under a court order now has to be released prior to the expiration of the commitment period?
I don't know what the answer to that is,
More
Your
than
Honor.
two?
Well, what I would say is that somebody should have been reviewing at the hospital what was being done here. This person was being sent out the door after being on 5-minute watches, with the family being told, go get a restraining order, when he was a homicide risk. He remained a homicide risk. And he did exactly what he said he was going to do. He committed murder, I think it was 3 weeks later, using knives that he kept in his room. His mother confirmed that he kept knives in his room for no apparent reason, and they were in fear of him. Somebody should have reviewed what this doctor was doing when she sent him out the door.
But we need to know the extension, if the decision is as you're asking.
Right.
You know, we sort of need to know the reach if we're gonna have this duty. And so the corporate hospital now is going to have a sort of anticipatory peer review. And the question is, how many people have to be in? So what if the initial psychiatrist says, yes, we no longer have substantial harm because of mental illness? The next person says, no, we disagree. Now you bring a third person in, or is it 3 out of 5? What's the duty here?
Your Honor, I honestly don't know the answer to that, but what I do know is that 0 is not enough.
Well, we don't have 0, we have 1.
No, we had 0 oversight of this one
okay.
doctor's decision. 0.
Can I ask, this is a national model, right? It's a Tarsonoff immunity provision, right?
Tarasov's a little bit different. Tarasov was a failure to warn a known or an identified victim.
But that's what our statute limits
Yes.
It has the exception unless you're an identified. But
Yeah.
So have other courts adopted in any other state your position where, okay, the legislature's created this, and I mispronounced it, Tarasov or whatever, immunity for psychiatrists,
Right.
but that immunity doesn't cover the hospital. Have they ruled your way? Because I'd be
Yes.
very useful to know which cases have done that.
Yeah, I'm actually just looking for that right now. Wait a minute. There's a string of cases.
And if it's in your brief, that's fine.
Yeah, but I really would like to find it. Oh, here we go. Yes.
It's page what in your brief?
Oh, I'm sorry. I'm looking at my notes. And
Okay,
It
okay.
is in the brief. But
Okay, go ahead, go ahead.
Colorado, Nebraska.
What's the name of the case?
Colorado would be Pereira versus State. Was negligent assessment leading to a
It's on
discharge.
page 40 of the brief.
Okay, thank you.
Okay.
Negligent assessment leading to discharge of a patient who later shot a police officer.
And they hold the hospital liable even though there's an immunity provision for the psychiatrist.
I don't know if, honestly, candidly, Your Honor,
that's
I
the-
don't know that there's a statutory
That's
immunity.
the issue for us, right?
Okay, and
I'm
the
just-
short answer is, I don't know. I don't know if the states that I've cited have a statutory immunity for the,
Right, because it doesn't mean anything if there's no immunity, but if there is immunity and they do this, that would be useful. I understand now your mass tort claims, although I want to think through that, but it seems illogical when this kind of decision has to be made by a psychiatrist, but if courts have drawn the distinction, it'd be very helpful to know that.
right. And I don't know if those states have immunities, probably a half a dozen cases that I cited.
Doesn't this appear in a lot of states, this provision?
I'm sorry.
Doesn't this immunity provision appear in a lot of states?
It does. It does.
Okay, but you haven't been you're not sure if there are any cases adopting your interpretation
Well,
of this?
there actually are. One of them, and I'm going from memory, one of them was decided by Justice Cowan before.
That's a very different case. That case is someone jumps over a fence or something. It's not a release. It's not this kind of case, right?
Well, but no, it's a duty to control, and there are a couple cases in the
No,
Commonwealth.
but I'm trying to focus on the exact issue we got, which is the person who has to release somebody has to be a trained professional.
Right.
And if you're if there's a gap between the professional and the hospital, it would be really helpful to cite a case that does that.
Well, I know that all of those cases that I've cited from other jurisdictions are talking about negligent release, that there was a duty to perform an evaluation, and that evaluation was questioned to be faulty, and that's why the cases went forward. If I could just briefly comment on two things, I know I'm about out of time, and that is what we're citing the court order for. We're not saying that there's an automatic cause of action for violation of a court order, but what we are saying, or I am saying, is that the court order created a duty. There was a duty to act. And in this case, we're saying that the court order was directed to the Caritas Kearney Hospital. I know that there's a provision in there that says deliver the person to the superintendent of the medical or the medical director, but that really is nothing more than a delivery instruction. The court order went to the Caritas Kearney Hospital. It was a misnomer, and the people at Steward knew that it was directed to Steward Healthcare Systems. Two cases in the Commonwealth support the proposition of a duty of care where one is in custody. One is Jean versus the Commonwealth, and the other is Irwin versus the town of Ware. Both cases, they had custody of the person, let them go, and injury followed. I know I'm out of time.
All right, thank you.
Thank you.
Mr. Mahoney?
Thank you, Your Honor. May it please the court, I'm Ted Mahoney, and I represent the defendants. The Tarasoff case that has been mentioned was the first to articulate the balance, or a balance, of protecting the privacy rights of mental health patients along with their need for effective mental treatment, as well as the public interest in being free from violent assault. And the Massachusetts legislature did weigh in on that issue in 1989 with GL Chapter 123, Section 36B. What that statute did was it created a duty on the part of a mental health professional, and thus permitted and actually required that the professional disclose what were otherwise confidential communications. And the duty that the legislature established in 1989 contained two circumstances in which that privileged communication must be breached. And that, as you all well know, is if the patient communicates to a licensed mental health professional a threat to kill or
I think we
seriously.
understand the statutory language. Your brother has presented this dichotomy, saying, okay, the licensed the licensed medical professional gets this, but the hospital doesn't get it. And your argument was, well, that's illogical. And that seemed attractive to me, but he is right. Sometimes we draw distinctions. For example, we do the opposite for hospitals in terms of medical. We have charitable caps for nonprofit hospitals, but you can sue the doctor, right, for, medical malpractice. This is kind of the inverse, he's arguing, of that. Are there any cases out there that do the opposite of what you're saying, which is there's a Tarasoff immunity, but you can still sue the hospital? Are you aware of any? Because I'm going to go read the cases on page 40, but
Right.
You could save me some time if there are some that are out there and
Sure.
you can distinguish them.
Right. So the cases on page 40 of the appellant's brief, you'll notice in most of them, and I think it might be every one but one, it's a case against the state. And of course, that happens in these types of cases because it's often state hospitals that care for these types of patients. What happens in those types of cases is it brings in a number of different issues that distinguish those cases from this case, and that is the liability of public employees, public employers. You asked an interesting question in the prior argument about whether there are cases where the actor is immune but the employer is not, and the reference was to Chapter 258. But Chapter 258 has a legislative framework where it specifically says that if a public employee acts, then the public employer can be responsible. That's all set out. That's not the case here. So in answer to the question you asked me, I think it is very difficult to get a case that's on all fours with what we have here, because what we have here is a court order sought by a psychiatrist, and then we have in this case, a private hospital, in this case, someone who's not a public employee making a decision, and an attempt by the plaintiff in the case to say, in essence, you're responsible for that decision that was made, even though he's not claiming in the case that there's any vicarious liability. So where the duty comes from, I think, is the question.
Okay, well, I'm going to read you what the district court mental health standards say with regard to the district court's understanding. It says that
The state district court, Your Honor?
this is our district court, right? This is the Massachusetts District Court as part of its quite detailed mental health standards. Treatment responsibilities and the authority, this is section 4.06. Treatment responsibilities and the authority to release or transfer a committed person prior to the expiration of the 6-month or 1-year order of commitment rests with the superintendent of the facility, or in the case of Bridgewater State Hospital, its medical director. Do you disagree with the district court's understanding as to whose responsibility it is to determine whether or not the individual no longer poses a likelihood of serious harm by reason of mental illness?
So I can't disagree with their understanding. However,
Are you saying that's legally correct or legally incorrect?
I think it would be illegally incorrect if the superintendent does not have the capacity to make the judgment about the patient. So the judgment about the patient has to be made by a qualified mental health professional. So if the superintendent happens to be the person who is caring for that patient and making the judgment, then yes, but the judgment has to be made by a qualified psychiatrist.
Okay, let's assume that's the case. Why do you assume that the Tarasov statute applies in this? The Tarasov statute was focused on some individual during the course of what is otherwise a confidential communication, speaks of desire to injure somebody, provides all sorts of information which may potentially cause a mental health professional to have concern. Tarasov speaks of it, the statute incorporates it and says, here's the balance. You only need to disclose if you have reason to believe or strong reason to believe that he's going to injure a particular person, then the privilege is waived and you have an obligation to warn. Otherwise, we're going to protect you for maintaining that privileged communication. This is a different animal. This is where the judge has found that the person poses so serious a risk of serious harm that the judge is going to say, I order his liberty to be deprived for a period of up to 6 months, but I am going to do what we almost never do as judges. I'm going to delegate to somebody else the decision to determine whether or not that person no longer poses that likelihood and can be released. It's a rather extraordinary thing for us to do. I don't know of any other context in which we do it. Your view is that if that decision is made by the superintendent, perhaps in reliance upon a medical professional, even if that view is totally reckless, even if it's viewed purely on the idea that we want to save money because it's keeping somebody in a psychiatric facility with Medicaid paying is a loser for us, even if it's a totally reckless, irresponsible decision, there's no liability.
I would say that there's no liability on the part of the corporate defendant that in and of itself can't make that decision, yes.
And counsel, your understanding of that rule that as the chief just articulated, the district court mental health standard there, would that actually create a liability standard for a hospital, or would that be more appropriately challenged in some way as a misstep by the judge in terms of permitting that outcome? And so perhaps by the patient, like, you shouldn't have delegated it to this doctor, you should have brought me back into court, or by whatever state agency may have an interest in it.
Yeah, I'm not sure I understand your question, Your Honor. I don't think it would create a new duty if
That's sort of my
that's
question.
the question you're asking.
And do you know, do all mental health facilities have superintendents?
Interestingly, in this particular case, the petition was actually requested by Dr. Henry, who happened to be the medical director, understanding that Kearney Hospital is not simply a psychiatric facility. It's a hospital that provides medical care and treatment, surgical care and treatment to patients as well. But I think, Mr. Chief Justice, I think that the language of the statute is actually broader than the court may be suggesting. It does specifically say that there shall be no duty, yes, to warn, but also to otherwise protect. And although Shea was different, one of the claims in Shea was that the patient should have been hospitalized. And what the Shea court, when addressing that issue of is this simply a duty to a warn case, a statute, what Shea said was that we find it that Section 36B clearly abrogated any common law duty owed by a mental health professional to a patient, and then further said it is impossible to glean from such strong language the intention to permit additional liability based on common law. So at least Shea, looking at that, albeit in a situation I understand was a little bit different, they talked about what they perceived to be the strong language of the statute.
But I'm trying to understand. I mean, you're saying then that the mental health, I mean, I understand that the superintendent will have to rely, arguably, on the persons who are within the employee or the person who are authorized to operate on behalf of that hospital. But I'm positing, again, I'm not suggesting it's this case, I'm positing an absolute reckless disregard for any obligation with regard to it, that the person does not do any particular analysis and simply says, we're going to release this person. And you're saying that that the statute gives the mental health professional who was reckless and the superintendent who perhaps didn't even rely upon any mental health professional's evaluation, but decided this is costing us money. We're going to get this guy out of here. He's a pain in the rear. He's being problematic for my staff. I want him out. That there's absolutely no liability with regard to that.
I'm sorry, no, I misunderstood you. That's a different case. And that's not our case
Okay,
here.
so then there is a duty. What is the duty then?
The duty on the part of the hospital, I would say the duty on the part of the hospital is to keep the patient who is under an order to be legitimately kept, in the same way that the duty of a jailer is to keep someone who's supposed to be in jail.
I'm referring to a decision to release. Is there any duty with regard to a decision to release, or can that decision to release be done irresponsibly, recklessly, without any factual or sound basis?
So I think under the statute that there would be no duty under the statute for an individual provider. If it's done with the knowledge of the hospital that's there and those that control it, that someone is absolutely reckless with no regard, could there be duty there? I wouldn't leave that out of the question for there to be a duty there.
Okay, so there might be, there is a duty. The question is, what is the scope of that duty?
Well, and I believe the scope of the duty is for the hospital, as I just mentioned, to keep a patient who's legitimately supposed to be kept until a licensed mental health professional makes a judgment.
Okay, so you're saying then the duty is simply to act in reliance upon a licensed medical professional's judgment without any evaluation of that judgment?
I think that hospitals have some obligations to ensure that their providers are providing, in general, appropriate care. And I think that hospitals in general, and Kearney Hospital is a hospital, have an obligation to make sure those on their staff, even though not employees, are practicing appropriately. I think that's a duty that I think all hospitals have.
Okay, so I'm just trying to sort this out. So you're saying then that the hospital does have some duty, and that duty would be to you could rely in good faith upon a judgment, but you would need to do some due diligence to determine what the factual basis was for that judgment in order to determine whether it is appropriate to rely upon.
In a general sense, to understand how someone is conducting themselves as a provider, not in a specific case.
Okay, I don't know what that means. I mean, right now we have somebody dead and somebody who is suing, saying that the hospital breached its duty by negligently, recklessly, I don't know, releasing somebody which they should never have done. So let's speak about it again. I don't know the facts. I've not read the affidavit. I'm just trying to ascertain the existence of a duty, and if there is a duty, what the scope is of that duty.
I don't believe there is a duty for a corporate institution to review the decisions made by individual mental health professionals with regard to whether the standard established by the court order is still in play.
Okay, so does the hospital have any duty?
The hospital, I think like all hospitals, would have a duty to make sure those on their staff, in a very general sense, are qualified to do the job that they're doing of providing care.
Okay, so you're saying that the only duty then of the hospital is to act in reliance upon the opinion of a medical professional?
In a situation like this, yes. Yes.
And is there,
Well, that has to be further than that, doesn't it? I mean, the chief's point, you could be negligent in the hiring and retention of that psychiatrist, couldn't you?
Absolutely.
So you've got a certain.
Well, first of all, I'm sorry.
Yeah, no, I'm just want to make sure, because the chief's asking questions that I'd like to better understand, because there's got to be you can't have an incompetent psychiatrist on staff without, right? I mean,
Yes.
you've got to have negligent responsibilities for that.
I agree, and they're not hiring them to be on staff. They're giving them privileges to work at the
But the
hospital.
same thing, you've got,
But
you
you're
can have
right.
negligent privileging too.
You could, yes. Certainly, hospitals have obligations to make sure that those on their staff are qualified to be on the staff.
So in response, though, the chief's question, though, as long as you've as long as you've selected or privileged this person without committing negligence, no matter how negligent they are, the hospital's off the hook because of this immunity provision. Because there's got to be a duty of care owed. The question is how much of that duty is gutted by this immunity provision, isn't it?
Well, I think that to take another example that may be off point, but it's just coming into my head.
Mm-hmm.
If someone down at Mass General has surgery and the surgeon is negligent as all get out, that doesn't mean that Mass General is responsible for it.
That's
That
because
may
there's
put
a
them-
charitable immunity.
No, it's not. No,
You're
Your Honor.
suing.
The charitable limitation has nothing to do with whether a hospital is liable or not. It simply limits the damages if there is a verdict.
They're liable if they've improperly certified or privileged that doctor, aren't they?
I'm not familiar enough with exact statutes that would apply, but it would seem to me that there's some burden on the part of the hospital to make sure that those who are privileged to do certain things are qualified to do it.
Yeah,
Which I
take
think is-
my word for it, there is.
That's-
There is.
Yeah. I would
That's a
think so.
different question, though, than what's presented here, isn't it? In terms of, aren't we focused in this case on whether this judgment, if this went the normal route that a case would go, you'd have a claim against the practitioner if there was not the statute, and you'd say, well, was that decision that the practitioner made reasonable and or whatever the standard is, and was it negligent and reckless?
Yes.
And then once you had that conclusion, you would keep going.
Yes.
Up the vicarious liability chain, which is not really the same. You could
You
make-
could do that. That's
arguably.
not the claim here.
But that's not what's going on here. Okay,
Right.
That's what I want to make sure.
I'm thoroughly confused by the scope of the duty that you admit to. So under the statute, the licensed mental health professional has no duty, quote, to protect a potential victim of victims, right? So there's no duty owed by statute to potential third parties by the mental health professional.
Except in two situations.
Yeah, exactly.
Yeah.
Which ones aren't applicable. So anyway, now we get to the potential duty of the employer of the facility. And clearly, as has been discussed, if the hospital hired someone incompetent, knew they were incompetent, and set that person out to do these evaluations, there'd be some liability by the hospital.
One would think that the hospital would have some responsibility to make sure those on its staff were qualified to do what they were
All
supposed
right,
to
so
be doing.
tell me what, in your view, what the scope of the duty is in these scenarios.
In the scenario that you raise, I think
Right.
the scope of the duty for a hospital is to privilege in the hospital those physicians or mental health professionals who are qualified to provide care in which they specialize. And therefore, they privilege those physicians. Physicians apply for privilege as a process of credentialing, and I think that they would have a duty or burden to make sure that the credentialing process is done appropriately.
But also, it's got to be more than that. You also have to, you could have negligent retention of the person. Maybe they were fine when you hired them, but 15 years later, maybe they're not.
Absolutely. Yeah, I agree. And I think there's I mean, we're getting far afield from what I was anticipating, which is fine, but I think that there's a re-credentialing process in hospitals where someone has to apply again, and they're allowed to do certain things, they're allowed to do certain types of surgeries or procedures, and others they're not. So I agree, it's a constant process and doesn't end when the person is provided privileges in 2000 and then just for the rest of his career or her career. Sure, but I think that the issue here, there's no claim that Dr. Johnson, who was the one who made the decision, was in any way anything but a very qualified psychiatrist. And
Do we know, I mean, if this were a Section 35 commitment, Section 35 specifically provides, a person so committed may be released prior to the expiration of the period of commitment upon written determination by the superintendent that release of that person will not result in a likelihood of serious harm. Is there any writing here by the superintendent?
I did miss the last part, Your Honor. Is there any?
Is there any writing here? Do we know what determination, if any, was made by the superintendent with regard to?
In this particular case, the decision, as far as I know, the decision to discharge the patient was not made by the superintendent, was made by a psychiatrist on staff who was the treating psychiatrist for this patient during the admission.
Do we know what, if any, what the basis was for that? Is that part of the record?
That's in the record, and she was deposed. Her deposition transcript.
I'm referring not so much to what, I'm referring to whether there's any record, contemporaneous record at the time of release.
Yes. There is in the record the discharge summary prepared by that psychiatrist in which she explains her thought process, and there also is a discharge order that she entered in the records ordering the discharge of the patient. So that is contained in the chart.
The discharge order was made by her?
Yes.
And not by the superintendent?
Yes.
So you're saying that the procedure for Section 8 is different than the procedure for Section 35?
Well, I wish I had more familiarity with Section 35. I apologize, Your Honor, but I think that the order that entered in this case at the request of the psychiatrist didn't specify as to how that decision gets made, but simply says that patient will remain there until these criteria are met or not met.
Well, I think it specifically speaks of the determination by the, is this the order?
No.
Oh, I'm sorry, no, I was trying to go back to the order, but I think the order does speak about a determination by the facility. And I don't have it
I
with
think,
me, and because
I
we're
have the language
paperless-
here which I can
Yeah,
read.
if you would.
It says, therefore, it is ordered that said person be committed to the Caritas County Hospital for a period not to exceed 6 months or until there is no longer a likelihood of serious harm by reason of mental illness, whichever period is shorter. And the court officers or other officers duly authorized are hereby commanded to remove said person to said hospital and deliver said person to the superintendent or medical director and to make a return of this warrant with their doings and so forth.
And then I guess you'd incorporate then essentially the district court mental health standards, which speaks about the responsibility resting with the superintendent. And you're saying that's not whether or not that's the law, that's not what happened here.
That is not what happened here. The decision was made by an individual psychiatrist, and I know my time is well up, but if I could say one further thing, and that is that a decision that the duty under these circumstances is on the facility will place that duty on a facility that can't make clinical mental health judgment. That, by the way, not every provider at the hospital can even access a patient's records. And so if we're talking about liability of a corporate institution, what right does someone who's in the corporate institution, not treating the patient, have to even open up the medical chart of the patient? The mental health providers who are providing care can, but in hospitals these days, there's an awful lot of attention paid to who is accessing records and who has the right to do it. So with no ability to itself make clinical decisions, and with no right to even potentially access records, that duty is on a facility where, at least it's my position, that the mental health provider does not have that obligation, does not have that duty, or cannot be liable for those decisions.
So you're saying that the only duty of a facility is to rely upon a mental health professional, and that you're saying that the statute provides absolute immunity to the decision of that, or to the determination of that, regardless of whether it was reckless or negligent?
Well, I think that the facility, once the condition of the order has been removed, once the decision has been made by the treating psychiatrist, I don't think the facility has the right to keep the patient.
All right.
One last question. You mentioned a case. There's one outlier case. When I was asking you about page 40, you said, I just want to make sure I read and understand your interpretation of that odd case, because I take it that odd case doesn't go your way.
I don't think, Your Honor, what I said was, I thought that all of the cases cited, except for perhaps one, involved the state, which brought in a whole number of other issues. As I looked through the cases, one of them did not involve the state, and I'm having trouble remembering. I don't have it on the notes of which one it was, but there was, and I apologize, but there was one, as I read it, that didn't involve a claim against a state.
Okay, thank you.
Right, we'll take our morning break.
Court will rise.